Good afternoon, everyone. My name is Conti Morris-Smith, and I'm a family law attorney practicing in the Central Florida area. Today, we're going to talk about father's rights and what a father has to do in order to establish his rights. In Florida, according to Florida Statutes 744.301, the mother is the default custodian of the minor child until there's a court order that states otherwise for a child that's born out of wedlock, okay? So what that means is that if the parents are not married and a child is born, Florida law considers the mother to be the default custodian of that child. And the mother is allowed to make the decisions and to have primary custody of that minor child until there's a court order that states otherwise. So it's really important to make sure that if you're trying to establish your rights, that you understand that as a father, you do not automatically have rights and that you have to take steps and be proactive in order to establish your rights. So a lot of my clients call me and they say, you know, I signed a birth certificate. That's my kid. I should have rights. I understand that. And I agree with you, but the law states that even if you sign the birth certificate, that's not enough to establish all of your rights as a father. So in Florida, you can be on child support, right? They can acknowledge paternity and put you on child support, but still not, you still will not have rights to your child as far as overnights, making decisions about what school for the child should go to, claiming the child on taxes. So even though you acknowledge paternity and you sign birth certificate, you still don't have your rights as it relates to time sharing and making choices and decisions on behalf of your child. Now, another issue that comes up often is that the mother or the father learns that the mother is trying to relocate with the child and move out of state or somewhere, you know, South Florida. You live in Orlando, and the father doesn't want that to happen. So this is where, you know, it's crucial that those fathers quickly start to establish their rights, because the mother, since she is the default custodian, if the child's born out of wedlock, the mother can relocate and go wherever she wants to go if there's no petition filed or pending or in court order regarding time sharing or relocation. So if, you know, the mother just ups and leaves and moves to California and calls the dad and says, hey, we're in California, there's not really much you can do at that point as far as making her come back and bring the child back to Florida. So if you have an issue with you're concerned about the child relocating and you are not married to the mother, it's important that you contact legal counsel, especially here in Florida, to assist you with that issue. Now, a lot of people talk to me about, you know, well, I'm on child support, but I can't see my child. I can't get them for overnights. I don't get to spend Christmas with them or their birthday. You know, what can I do? And so what you have to do is file a petition to establish your rights and to request that you be able to engage in shared parental responsibility with the mother of your child. So until you do that, right, until you take those steps and you file a petition, you know, the mother can kind of do whatever it is that she wants to do as it relates to time sharing. Now, people get really frustrated with that, and I understand that completely. But understand that if the mother is texting you messages saying how you can't see the kid, or they're refusing to allow you access to your child, we can still use that evidence when it's time to present your case at trial or at a hearing to show the mother is not allowing you access to the minor child. So even though it's frustrating, it's important that you create a paper trail that you document via emails and text messages, you know, about what's going on and about the mother not allowing you to see the child. Okay. Now, once you establish your rights, right, you file a petition, mother, and this is separate from child support. So you could be put on child support and still not have your rights. So child support judges and hearing officers are not going to really get into overnights or time sharing. They're going to deal with, you know, what's going on as it relates to just the child support amount that's owed and your income, the mother's income, and calculating that. So they're not going to really get into that. So the way you get into that is by filing a separate case. Okay, it's a petition for paternity and time sharing. And in that case, you make your request for what you want for time sharing. Do you want equal time sharing? Do you want, to have a long distance parenting plan? Do you want to be able to participate in making decisions for the child? Do you want to claim the child as a dependent or get any exemptions for the child for tax purposes? You plead all of that in the petition for paternity, and then the mom is served with that is served with that petition, and then she has 20 days from the date of service to respond with whether or not she agrees or does not agree with what you're asking for. At that point, what happens in Florida is that you exchange financial records, okay? I see a lot of cases where the father's paying a high amount for child support, and it's because the child's in daycare. But in the child support case, there was never any discovery conducted or an investigation conducted to verify the amount of child support or the amount of daycare that the mother was paying. Right. So what we do in the paternity case is we go through and look at, let's get verification of what's being paid for daycare. Let's verify what the income is. Let's verify, what the amount is for health insurance. Right. So you verify all of those things. And then we figure out, okay, can the parties agree in mediation to a time sharing plan? And if not, then we move forward and we have a hearing or a trial in front of the judge, and the judge will consider the factors and determine what's in the child's best interest and award overnights. If you have at least 73 overnights, which is 20% of overnights, it's not the amount of hours you spend. What matters is overnights in Florida when it comes to calculating child support. So if you have 73 overnights or more a year, and that's court ordered, then you're entitled to a deduction in your child support. Okay. And so when we're calculating child support, you are calculating child support based off of the net income of the parents. We're looking at the amount of overnights each parent has, who's paying for health insurance and what's the cost of health insurance, and who's paying for any daycare, summer camp, after school, before school care, and the amount of that. And then everything gets put into the formula, and a child support number is generated at that point. And we can't deviate too much up or down based on that number. Now, one thing I always hear people say too is that, hey, I want to waive child support, or, I don't want to put the other party on child support. Well, in Florida, child support is a right that belongs to the child, right? And not the parents. So the courts do not have to agree to waive child support. Okay. It's not based off of the agreement of the parents. It's based off of providing for the child. So keep that in mind when you're moving forward with your case as it relates to paternity and to child support. Now, what you can do in Florida is once you file petition for paternity, you can also request that your child support be modified based on the amount of overnights you're getting. Okay, so in Florida, you can modify your child support based on a substantial change of circumstances. So if your child support was originally calculated and you weren't getting overnights, and now you file your petition for paternity and you're moving forward and you have a court order for time sharing, we can also modify your child support in that paternity case. People ask me, I want to claim my kids on my taxes. Okay, we have to petition the court and ask that you're able to do that. It's important to note that typically you will not, if you have any sort of child support arrearage or you owe back child support, you won't be able to claim the child until you're current on those past obligations. If you're allowed to claim the child or whatever the tax code allows for at a particular time. So, keep that in mind. You have to be current on your child support for trying to get a benefit for taxes and to be able to alternate that with the mother. So let's talk about if you're trying to modify your child support. If say your income has changed, right? So during COVID, people lost their jobs, or their hours were reduced, and they want to file for a modification of child support. In order to modify your child support, there has to be a substantial change of circumstances, and it has to be permanent. So if you were to file a modification and you lost your job 2 months ago, that's not going to be considered permanent. Under Florida law, permanent is considered a year. Okay, so we can't just modify child support on a temporary basis. We have to be able to show that this change in your income, this change in your, your job, as a permanent change and not just a temporary change. So if you're looking to modify your time sharing or modify your child support, you have to make sure it's a permanent change and there's been a change in your income as well. Now, let's say, for example, you have an order, right? An order for time sharing. It's been ordered. You guys litigated it, and you're supposed to get your child, every other weekend. And we, in the courts, modify your child support in that case to give you credit for the overnight that you're getting with your child. If you stop exercising your time sharing, that can be a reason or a why that your child support can be modified to go back to the higher amount because you weren't exercising the time sharing that you were court ordered to exercise. So it's really important to understand that just because you get the order, you have to actually take part in the time sharing if you want to still benefit from the reduction in child support. In what situations can a father get full custody? It's really hard for anyone to get just full custody all together, right? You have to show that it's not in the child's best interest to have access to the other parent. So that's a really difficult task to try to accomplish, to get full custody. But if you have a situation where the mother has neglected the child or the mother has abandoned the child, in those cases, you can get, based on the facts, what we call sole parental responsibility, right? And the other parent may still be allowed to have some sort of supervised time sharing. It just all depends on the facts. But to get full custody, it's very difficult here in Florida, and it's a high burden in order to try to get that. But if you can show that the parent is detrimental to the child, or the child's going to be harmed by being around that parent, it's possible. But it all depends on the facts of your particular case. How does moving out of the state affect visitation rights? And who's responsible for transportation? If someone is going to, say you have parents that live here in Orlando, and they're doing 50-50 time sharing, and then one of the parents decides to relocate to California. Well, it's going to be hard to continue 50-50 time sharing with one parent in Florida and one parent in California. So you're going to have to adjust the time sharing schedule to maybe a long distance plan where the parent that's relocating perhaps may get the child for the majority of the summer, a majority of the school breaks, spring break, long weekends, right? Because it's going to be hard to have a child travel back and forth every other weekend. So depending on the flight, depending on the cost of travel, we'll have to figure out what's a good modified time sharing plan that works for that particular family. Now, according to case law in Florida, the parents are supposed to split the cost of transportation. And that can also be something that's factored into, child support, as far as, is one parent paying $400 for, 6 tickets throughout the year, or how can we, factor that in to the child support obligation or give them a credit for that. So according to the law, parents are supposed to split the cost of transportation. So if, even if the parent relocated, then the parents will split the cost of getting the child back and forth for their time sharing with the mother and the father. Is there a statute of limitation for getting paternity? No, but I mean, if you wait until the child's 18, it's kind of too late at that point to try to say, hey, let's establish our rights or whatever else. I mean, if you're paying child support for a child, they've acknowledged that you're the father, and you are, for legal purposes of paying child support, you are the father of that child. So if you wait until, you can't wait until they're 17 to file petitions, say, oh, I want time sharing now. It's kind of, you're late if you do it at the age of 17. But, what's important, the court's going to look at, why are you doing that? Why are you doing this right now? Right? Why are you filing for time sharing right at this moment? So you don't, if you just got put on child support in the Department of Revenue, and then right after you are hit with $1,000 a month for child support, you turn around and say now you want overnights, the judge may look at you funny because it seems like you're doing this just because you were put on child support. So what I encourage all fathers to do is that if you want to spend time with your child, that you file the paperwork sooner than later so you can get your rights and have them established. In a lot of cases, fathers are saying, well, I'm not getting time sharing for the holidays. I can't get my child for Christmas or for New Year's Eve or for, Thanksgiving. Well, if you go to court and establish your rights, you'll get a court-ordered time sharing plan that will also most likely alternate the holidays and allow you to have access to your child during the holidays. But again, we see it all the time. You get hit with child support and now you want to reduce your child support. So now you want time sharing. If the child's 11, 12, are older and you've never been a part of their life, it's going to be hard to come and request 50-50 time sharing at that point, right? Because there's no history of you being involved in that child's life. Can you help the father get time with the child when the mother or parent keeps the child away? Absolutely. As long as you're not like a child molester or something that's crazy that's going on with your history, we can petition the court and ask for time sharing. It comes down to, how involved are you in the child's life, and it's important to make sure that you keep a paper trail showing all of your attempts to get time sharing with your child. You see it a lot when we get to court and the mom's like, well, he never asked for the child. He never, he's never asked for him until he got put on child support, right? And as a father, you want to have a record that says, I did ask for him. I asked for him all the time. I asked for him, for the holidays. I asked for him, every other weekend. And what you see a lot is that people, and men especially, get frustrated, right? They just get frustrated and they shut down. You can't do that. It's important that you keep a paper trail, that you continue to ask to see your child, even if the mom's being ridiculous. Let her be ridiculous. And then you can show the judge how she's being ridiculous once you get to trial, right? You can show her the emails or the text messages that she didn't respond to. You'll be able to show the judge how she, has kept you from your child. But you cannot get frustrated and give up. You have to be persistent and make sure you create a paper trail that we can go to court and say, look, judge, she's being unreasonable. Give dad time. What should I do if I get a letter from the Department of Revenue about child support? Call an attorney. If you are in Florida and you receive a letter, an administrative letter, or any letter regarding child support, do not bury your head in the sand, okay? You need to deal with it. There's a lot more that an attorney can help you with on the front end versus trying to help you with on the back end. In Florida, you can get put on child support without having a hearing. They can send you a letter. It's called an administrative proceeding. They can send you a letter and put you on child support and without a hearing or anything, right? So a lot of people call me like, oh, I was never served. You don't have to be served, right? If it's an administrative child support case, they can serve it to you by mail. And you have to respond. When you get that notification, that letter, they have certain deadlines. Like if you want to have a hearing, you need to opt out or let us know within 10 days or 20 days. It's important that when you get those letters, when you first get them, that you contact legal counsel to assist you and to provide you with all your options. Because for an administrative case, we can get that dismissed if we do it in a timely fashion and move forward with your paternity, time sharing, and child support in the paternity case. Okay, so that's going to save you money because you don't have to litigate in two different arenas. You don't have to litigate in administrative court and then also in circuit court. So, but it's about timing and making sure that you get, get an attorney on your side to help you with this as soon as possible. Does child support terminate? This is from Andre. At age 18 in Florida if the child goes to college? Great question. So in Florida, you do not get additional child support if the child goes to college. So child support ends or terminates when the child is 18 or they're 19 and they graduate from high school. All right. So there's no obligation to provide for your child above and beyond when they go to college. That is the best way to document issues with co-parents. Text messages. Okay. It's important to create that paper trail when you're texting. People communicate on WhatsApp. That's another good way. Facebook messages, emails. There's an app called Talking Parents where you can go on and both parents can communicate. You can download a file from there. What I encourage people to do is that if you're text messaging or you're sending messages to the other parent, that you keep all those messages and you do not screenshot them and send them to your attorney. It's better to download all the messages in one PDF and then send it to your attorney and identify which pages the attorney should look at. So, I mean, you want to have a paper trail. He said, she said, evidence can only get you so far. And if you both are saying different things, the court's gonna have to figure out, who they believe more. So creating a paper trail, and even if you are responding to something in a text message, so you say the mom told you when you saw the child that you can never see the child, you can respond to a message and say, hey, I know you said I can never see the child again, but I think that's unfair, and I want to see my child, right? So you're kind of throwing in what happened, and then you're, saying you want to see your child. So it's about, playing chess and not checkers, and making sure that you do a good job of creating a paper trail to show the judge how she's acting and how she is not allowing you access to your child. I don't know where my husband is. I haven't heard from him in 5 years. How can I divorce him? Well, you want to contact us for a consultation to discuss that and to figure out, if you have children or minor children, if you're trying to do custody issues, if you're trying to, how we're going to distribute your assets. So that for that question, it'd be better for you to contact us so that we can kind of go into your situation and figure out if we can find him. And it may be helpful to hire a process server to try to locate him before you hire an attorney, so you know where to serve him. If you, are interested in learning more about your rights as a father, or you have a family law issue in the Florida area, or the Central Florida area, and you need help, please contact us for a free consultation. We offer free 15-minute consultations. If you want a longer consultation, we offer those as well. But make sure that you know your rights. Make sure that you're proactive. Make sure that you're not letting anyone get in the way of you having a relationship with your child. Please contact us if you have any questions. You can post any other additional questions in the chat, and I can answer them in my next video. And remember to stress less and choose more.